Okay, I see it's 9:10. Can you guys confirm if you can hear me? Please just confirm if you can hear me. Thumbs up or anything.
We can
Just
hear
a
you.
confirmation.
We can hear
Okay,
you.
okay. Thank you so much for confirming. All right, all right. Thank you. So we're going to begin our session today. First of all, I want to welcome all of you guys. It's nice that you've been able to create this time that you're able to join, and we thank God for that. So we're going to start off with a word of prayer. Our Father, what in heaven, Lord, we thank you so much for this day. We thank you so much for this evening. We thank you so much for convening us here, King Jesus. As we discuss today, as we learn today, may you help us to memorize. May you help us to understand. May you help us to have the right answers, King Jesus. May you give us the confidence that we require. May you lead us know that we are all the decision that is in your name. So the mic that is on, whose mic it is, kindly just mute your mic is on. But I'm going to start us off, and I think, as usual, we're just going to start with some quick questions, maybe for the next 10 minutes. Any quick questions from anyone in relation to orals, in relation to any quick questions? If there are no questions, then I think we can begin immediately. Any quick questions from anyone? Again, we had made this before, but maybe someone forgot. The people who asked me if we are paying anything for this session, guys, again, just to emphasize, this session is for free. No payment from anyone. So please be free and feel free to join. Feel free to join. And I think it's better if you join than if you wait for the recording, because I mean, lately we've been having issues with the recording. But if you join, then you get it as we speak it. So again, this is just to encourage all of us. If you are able to create time and join, and be able to learn much. So I'm going to give this opportunity to Victoria McKenna just to say hi to us, give us maybe some quick advice, maybe whatever is on her mind. She was here in our first meeting, but I think she hasn't been around for a while. But I'd just like to reintroduce her. Then we can begin. Victoria.
Yes, hi Daniel. Can you guys hear me?
Yeah, lovely.
All right, that's wonderful. Hi guys, my name is Victoria. I don't think I've joined this session. I was in the first cohort, but I've not joined you guys. This is my first time. And first and foremost, I would want to congratulate you guys for reaching this step. It's not in KSL, even just taking the first step in oral, it's a huge step. So first, I'll say believe in yourself. That's the first thing that I would want to tell you. Believe in yourself, trust in God, and just in orals, essentially, what I usually tell people is that trust in God, believe in yourself, read the much that you can, and go ace it, because unlike exams, orals can be tested from every angle. So don't pressure yourself and start getting scared and worried, because that will literally drag you down. Instead, focus more on believing that you can actually conquer it, which is quite possible. You can ace it with a 20. This is the exam that you can get all the marks. So trust that you can gather those marks. So that's the person that I'll tell you. And be positive, study, practice, do these mock sessions often, even with your friends that can see your demeanor and correct you. Unfortunately, we are doing it virtually, so sometimes you may not be able to see what you are doing. When you do in front of your friends, they can tell you are fidgeting a lot, or you're doing this. They can also tell the ability of your voice. So as much as you're doing this here virtually, also get a group of your friends that you can be doing this with. Study. Sorry guys. Study with your friends that you can be able to get more. So, and also here during these virtual sessions, participate. It will help you practice more often. So that's all I can say, Daniel, for now. We'll keep interacting more as I guide you.
Okay. Thank you so much. Thank you so much for that. Guys, you can hear me clearly, right? Clearly as it can be. You guys can hear me very clearly, right? So I'm asking again, I'm just trying to confirm. I think there was some echo when Gloria was speaking, when Victoria was speaking. Sorry, Victoria. You guys can hear me, right? Thumbs up, anything?
Yes, we can.
I can hear you, Daniel.
All right. Thanks. That's nice. That's nice. That's okay. That's good. So I don't think there's any hand that is raised yet, but Angelo, you can say hi before we begin.
Hello, guys. Good evening. It is good to have this session, and I appreciate that you guys have made time to join us. So it will be an interesting session. Thank you, Daniel.
All right. All right. All right. Thank you, Angelo, and thank you, everyone. So, guys, we're going to begin immediately. This session starts now. By 11, we should be done. Sorry, today we started a bit late, but I'm glad that you guys are here and you're ready to learn. So, of course, as usual, we always have a volunteer. So, we're just going to have a volunteer so that we're able to begin as quick as possible. Please don't be scared. Please do not worry. This is again, the way we usually say, this is the place where you make all those mistakes. Then we're able to correct those mistakes so that, when you go to the next level, you are able to be okay. This is a place where you come and, at least learn how it feels to be in that seat, so that next time when you're in the same situation, at least you will have learned one, two, or three things. So anyone who is willing to just volunteer before we begin.
Daniel, sorry, I believe Esbon is in.
Yeah. Thank you, Angelo. Husband is in. Okay. Any volunteer?
Daniel, before we get a volunteer, I was wondering, last week you had said that today we would get the opening statement for the Mackenzie case. Is it still on?
Oh yeah, Angelo, these guys have remembered. You gave a promise. Are you ready to proceed, sir?
You cannot forget the hour.
We cannot.
Okay, no problem. I have not prepared something, but since in dispute resolution department, I can come up with something.
Okay, so do you want to do it now?
No problem.
You want to do it now? Okay, go ahead.
Yeah, I will just keep it simple. I will keep it short, if not sweet. Okay. One second. All right, guys. I believe today I was supposed to give you an opening statement from the case of Mackenzie. So actually, it is still theoretical because what I described last time, it is not what is being charged, or we don't know what actually is going to be charged. We are just hearing things here and there from the minister or from the DCI. But last time I said we assume that he has been charged under the prevention of is it terrorism act, or others are saying that he's going to be charged with murder or mass murder. So I'm going to go with two. And last time I believe the person I asked was Mary Ann, who was going to be the prosecution counsel. So here we are. I begin. My Lord, my name is Angelo. I appear for the prosecution. My learned friend Daniel Odur appears the accused. My Lord, the case before you is all about pain. And when we are talking about pain, my Lord, this happened at a stage where everyone was quiet, everybody was going about their businesses. Then suddenly, from all parts or corners of the country, we find that someone is missing a brother, someone is missing a son, someone is missing a daughter. It is all about pain because of an individual who has been radicalized religion, who is using religion tell people not to eat, tell people to stay hungry in order to see Jesus, asking people to sell their property such that they can bring him the money, such that they can have that opportunity to see Jesus. My Lord, it is all about brainwashing, leaving everyone. It started with few people. Now, as we are speaking, my Lord, about 231 people have died. It is pain here, it is pain during the day, it is pain during the night. My Lord, this mass murder happened on the 1st of March of 2023, whereby it was discovered that there were missing persons in the area in a place called Shakahola. There is reason to believe that it was Mackenzie of Peace International Healing Center who has been brainwashing, telling people to sell their property, giving them all their property, giving them all their money, and asking them to stay angry. Our investigation have shown that all these people were murdered. Some organs missing in some of the bodies. It is just like the way that it is described, a man-eat-man society, because this is the clear definition of a man-eat-man society. During the course of trial, my Lord, we will bring before this court evidence to show how all these murders happened. We will call Miss Mary Jane, tell us how her daughter, who was working as a hostess at Kenya Airways, sold her property in Nairobi, came here to Shakahola. She will indicate before this court how her daughter disappeared under unclear circumstances. We will also demonstrate to this honorable court by way of evidence that some bodies miss important, significant organs. We will call the government pathologist, Dr. Jansen Odur. And upon conclusion of the hearing, my Lord, you will discover that you will all know any other finding but to find the defendant, Mackenzie, guilty of all these crimes. That's all, my Lord. Thank you. I believe that is something that I have just came up with right now. I have not written it down. It might not be perfect, but the gist of it is that it has to be short. You have to tell a story. I know you guys have heard me mentioning pain. I was trying to make the theme of my opening statement to be all about pain. And it is true, it is what is actually happening. Because at one point you had a son, it is gone. You had a relative, it is not there. So it has to be something. Your opening statement must have a theme and must have a theory, whereby now your theory is now entail you telling now your story. you have to be convincing. Okay. The aspect of opening statement, actually it is good where maybe in the US where we have jury, okay, and even United Kingdom. But here actually we still practice it. So the person you are trying to persuade is the judge. So maybe as we continue, I will prepare a better one, not on now fiction like what I have just done, but I was trying to show you you have to do it you, the way that I have just done it. So thank you, Daniel. That was a try on my part. I was struggling with facts, but yes, that's all for now.
Nice. Thank you, Angelo. We put you on the spot. I think what you've done is quite good. I think the class is able to learn one, two, or three things from what you've presented today. I think one thing that I really like about it is that you came up with a theme and you stuck to that theme. You stuck to that particular theme. You put it, in our heads, and we were able to hear it all through, losing a brother, losing a relative. This is something that you hear about today, and it's very sad. I mean, how sudden everything has happened, how fast things have moved, and all that. So I think one thing that we can really take from this is you must have a theme, create your story around it, make it as clear as possible, as short as possible. Of course, not very, very, very short, and at least try to tell the court what you are going to prove as you continue, or as the case proceeds. You have to really tell us, what do we expect, what do you think the court is going to, what decision do you think the court is going to make at the end of the day. But again, that must be built on a particular theme. So I think one thing you can take away from this: theme. Build your story around the theme, make it as clear as possible, then you'll be fine. McKenna, I think you used to be so good at this, and I think you still are. Anything you want to add when it comes to opening statements?
Yes. In I'd say an opening statement is essentially, as I think Angelo said, is telling a story. But remember, you are not just telling a story; you are telling your story. So, essentially, when you're doing an opening statement, even in an exam setting or in an even because you can do it during the exam setting or during orals. First is, if it's a crime, remember what are the elements of that crime, what is something that you need to prove to that crime, because that's what you are telling the court. You are showing them your story, your theme, and how you're going to prove them. It's just like you're inviting them to it. So as I'd say, ensure you just stick to your theme. Introduce yourself, as Angelo did, my lord, and in the matter, Miss Gitari, I prepare for the prosecution, and you can choose to introduce the defendant side or not. Maybe in your time you will not have been given information. Then you go ahead and say what the accused has been charged. And remember, because you are in the side of the prosecution, you are saying we will prove that this and this and this. Then finish by saying there are witnesses that you will call, and then because you proceed. So I think Angelo did essentially with that line, and that was good. So that's what I'll say. Say a story, but remember, it's not just a story. You are telling a story for your theme. So within that short time, get a theme. But I'd say the easiest way to get a theme is identify what elements needs to be proved. So if it's about men's share, if it's about actors' shares, you have to show to the court that you know what you're doing. So that's what I can say, Daniel. But when you are doing it in an exam setting where you are writing, then do it nice. Maybe orally, but even I think in oral exams you can boost your confidence and speak confidently. It can even give you points. So yeah, so that's all for me.
Thank you guys. I hope that is very clear now, and I want to believe that now we are able to move to the next level. Jerry, just to confirm, you're good? Mukuna and Jerry, you're good, or you'd like Angelo to maybe prepare now and give us a better one the next time?
No, no, if he decides that's okay, but even the one he has done today is informative, plus what Madam McKenna has added. Thank you very much for that. I appreciate it very much.
All right, all right, all right. Thank you so much, Jury. Okay, so we're gonna move to our first oral session. Anyone is present? Anyone who is willing? Any volunteer? So that we can be able to start. Please do not worry. Do not worry. It's just a few minutes and you'll be gone. Don't think about those who are here who will be hearing you. Just do your thing, man. Let me tell you, when those results come, yours are yours. They are yours. It's not about the 42 people who are here. They are yours. You don't share them with anyone. So this is the time to sharpen your skills. Just take it. Anyone? Any volunteer? Any volunteer, guys, that are able to begin? Any volunteers? Yeah. Welcome, Jerry. Glad and happy that you've decided to. Okay. How are you, Jerry? You there?
Thank you for having me. I am here. Good morning. Good evening.
Okay. Hi. So can I do this with you, Gitari? You're good?
Yes. You can go first, then I'll take it from there.
Come up. Okay. All right. So we're gonna have two people. So after me and you, I think we can have Angela and Hezbon. I think they're ready. Okay. Jerry, good morning. Or rather, good evening.
Good evening to you, and thank you for having me. My name is Jane Jerry from Class G, and I am happy to appear before you, and I'm ready to proceed.
All right, Jerry, that is nice. That is nice. Who is your LPM lecturer?
Sorry, I didn't hear that.
Who is your LPM lecturer?
You forgive me for that. I keep forgetting his name.
Okay,
I know that not in order. I will know his name by then.
Hi, all right. Who is your commercial litigation lecturer?
Mr. Wakimani.
Okay. And what about convincing?
Mr. Tom Odera.
All right, that's fine. Okay. Jerry, could you kindly just explain to me what the induplam rule is? What's the induplam rule?
Sorry, allow me to pass that for now, please.
All right. Okay, that's fine. What are the elements of negligence? What do you have to prove in court to, have the court decide that actually someone was negligent or not? What are the elements?
That there was duty of care, and that duty was breached, and someone was, as a consequence thereof, someone suffered because of the said breach of the duty of care.
Okay. And Jerry, how good do you know your constitution?
Fairly.
Okay. Would you like to discuss Article 27?
Yes, I would like to try.
Go ahead.
It talks about equality and freedom from discrimination. This Article 27 is in the second part of the Constitution that talks about the rights and fundamental freedoms. So under Article 27, it provides about the equality and freedom from discrimination. And it describes that to begin with, that every person is equal before the law. So this means that the status of different people, for example, whether rich or poor, or whether a politician or not, everyone is equal before the law, and therefore they should have equal protection by the law and before the law, and they should all benefit thereof. Article 27 also talks about the equality between men and women, and whether a man or a woman in any aspects of their life, they should enjoy equal rights and equal freedoms. So in mind is equal opportunities in regard to employment and any opportunity that is to be given. The article also talks about that nobody should be discriminated because of any ground, whether it is race, whether it is religion or gender. Yes, it also talks about everyone having an equal opportunity, that everyone should enjoy opportunities for employment equally. Yeah.
All right. So can a foreigner own land in Kenya?
No, a foreigner cannot own land in Kenya directly. They can only own land in Kenya indirectly through another Kenyan maybe holding it for them, but they cannot own land directly.
Okay. Under what regimes can someone own land in Kenya? What two regimes, just to lead you towards the answer?
Two regimes. I know there is public land and private land. I am not sure what is what you're making reference.
What I mean is, if I own land today, it's either I own it under one tenure or the other. What are those two tenures?
Leasehold. Freehold land or leasehold land.
Yeah. So I'd like to ask you the question again. Can a foreigner own land in Kenya?
A foreigner cannot own a freehold tenure. A foreigner can only hold a leasehold interest in land.
What's the maximum number of years?
90. Following the new constitution, all were taken back to 99 years.
Okay, they were taken back to 99. What was the number of years before?
999.
Okay. Last question from me. Types of bail, please.
We have police bail. We have bail pending trial. We have bail to avoid arrest. I'm forgetting the word that it is called, where you make an application saying that you're apprehensive that you could get arrested, so you ask for a bail. I know it has been controversial in Kenya, so there is that bail to prevent you from getting arrested, and there is bail pending trial, or as the trial is going on. Yeah.
Said that twice. You said bail pending trial, police bail, anticipatory bail. What's the other type of bail?
The fourth one is escape names.
Okay, that's fine, Jerry. That was really, 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 really nice. Victoria.
Okay, hi Jerry. I
Hi.
have a few question for you. What do you understand by the term res judicata?
This means that that has already been dealt with before an appropriate and a court having a rightful jurisdiction, that matter cannot again be heard. So res judicata means that it has already been decided, heard and decided upon, so it cannot again come before a court for hearing or for determination.
So let me ask you, in an instance whereby there's a matter that has been filed between one plaintiff, let's call her Njeri, against Daniel Odwor, and the issue of the matter was maybe an accident matter. If I file the said matter and I change the name of the plaintiff so that the plaintiff becomes Angelo, will that matter be res judicata?
No, it's only res judicata where it is the same matter, the same cause of action between the same parties. But if it is a cause of action like you have described, but it is another party that was not joined to the suit and was not in the same course of action, then this matter can still proceed. So res judicata is only where it involves the same action and the same parties.
All right. Okay, so my second question is, you have now become an advocate and you have your firm. The client walks in and it's an old mzee, and he tells you he wants to write a will. So he says he has 4 children, 2 sons and 2 daughters, and he wants to bequeath his properties to his sons, but he will not bequeath his properties to his daughters because they are daughters, they are girls, and they're also married. So, and he asks you for your advice while writing that will. How will you advise him?
I will welcome them and I will refer them to the provisions of the Constitution. That is part 2 of the Constitution that talks about equality and non-discrimination. I will also try to explain to them the findings of the court that have found that discrimination against the girl child, even if the girl has been married or not, is not in keeping with the provisions of the Constitution. So I will advise them to consider to include these girls in the will, so that once the will is written, it will not have a chance of getting questioned by these girls in court through, will not get a chance to be disputed. So I will advise them that the Kenyan Constitution considers all children, whether female or male, as equal children and having an equal right to inherit their parents' property.
Okay, so what happens if after you have advised your client the same and your client is still hesitant or insistent, that he's still insisting that he has to give his sons, doesn't want to give his daughters? As a advocate who's very conversant with the Law of Succession Act, how will you deal with that situation?
Having explained to them there and he's adamant, and I have told him the risk that he faces, I think I will just continue to draw the will as instructed by the client.
So do you think there's a risk?
Yes, I see a risk of the will being questioned, the probability of the court annulling the provisions of that will, and the property of them being going through intestacy, where if the will, I find a risk of the will being questioned and the Mzes will not carry the day.
All right. So in your opinion, does someone has a free will to bequeath his property how they wish? Does the law provide for that leeway?
Yes, I think it is section 541 of the law of succession, cap 160, that provides that one has freedom of attestation. But then again, in the same law of succession, it provides, like, for example, through, section 26 of this law of succession provides a right where there is, like, one can seek for reasonable provision where the will did not take full consideration. So even though the law of succession provides freedom of attestation, the same is not without a rider, or where the same can be questioned before a competent court of competent jurisdiction. And again, through the provisions that are therein, like the example I've given of section 26.
All right. Who's an advocate?
An advocate is a professional who has trained in law and has, after passing the bar exam, been admitted to the bar and has signed up the role of advocate and been recognized as an advocate, having signed the said role of advocate. Has signed up the role of advocate, and so takes up the title of an advocate.
All right. So let me ask you a scenario whereby you are doing your pupillage, and while doing a pupillage, your pupil master informs you that there is a matter that is coming up for mention, only mention virtually before court. But your pupil master leaves you with the instructions. Would you address the court virtually? And if you answer your question yes, explain why. And if you answer your question no, explain why.
Because a person who is supposed to address the court as should only be an advocate, as a pupil, I can only inform the court or request the court to extend the time or give a different time. Maybe if my master, I can introduce myself to the judge as a pupil and say that the advocate holding the matter is not in court, but is expected. So I can only do to the extent of asking the court to allow more time to allow for the advocate to come, but I cannot present that matter because I do not qualify as an advocate.
But you can address the court.
I am not sure whether that is addressing the court, like asking the court to allow my master more time. I'm not very sure whether that is addressing the court or it is something else.
All right. I think that's all from me. Let me just solve those questions. Thank you. Thank you for your trial. I'll just go ahead and give my views before I pass on to Angelo to ask the next question. So first and foremost, I want to congratulate you for trying. That was a good one. That was really good. You are confident and you did not, in my questions, there's no one that you passed. You were able to attempt all of them. And so I'll give you, that's a good one. I'd say, and also you kept explaining yourself. That was good. I'll say for me that you read more, and when you are when you're answering a question, especially a question that you know the answer, just go direct to it. But essentially, I think you got all my answers correct. And the situation of a pupil, the real answer is no, because you are not yet an advocate. I had asked you a question about advocate, and it's only an advocate that should address the court in the matter. So you also cannot hold brief because you are not an advocate. I don't think there's any other question. Oh, the question about the succession matter, about the writing of a will. I was just trying to test and see if you are aware that someone can have a free will, and also about equality. And I think you got that, or rather you answered it correctly. Rest Judicata, you did answer it correctly. I don't know if there's any question that I've not responded to, but in my point, you did get almost all my questions correctly. Yeah, so just work on your audibility and tackling the question directly, but all in all, you are good. I think Daniel has just walked out kidogo, but I also think there were some few questions that we were not able to answer in his part, and that they were the ones that you passed. Maybe when he comes back, he'll address them, but that was good. Jerry, keep up and kupige makofi. There you go.
Thank
Angelo,
you.
you succeed.
All right, Jerry. Jerry, thank you so much for being our first attendance, or the first person to volunteer. Now I would invite our next volunteer. I believe me and my learned friend Esbon will be very, very good with you. So, who is our next volunteer? Please raise your hand. Time is not on our side, guys. Very well. Victor Gunjiri. You can unmute, please.
Yes.
All right. Thank you, Victor. Esbon Oko, please begin with him, then I will take it over from there.
Most obliged, my lord. Anyway, so good evening, Victor.
Good evening, Mr. Esbon.
All right, now for the purpose of our session, consider it is actually in the afternoon. So you are appearing before myself, before Angelo and myself. So kindly introduce yourself.
My name is Victor Munjiri. I'm in class B. I'm in class B, yes, in the morning class.
Okay, now thank you, Victor. So I have some few questions to you. I just request that you, in your answering, just show a bit of understanding in them. So the first question I have is that you are a conveyancer, or rather an advocate practicing conveyancing. You get me, right?
Yes.
Okay. Now, you are an advocate practicing conveyancing, so you are a conveyancer. So you realize that you prepared an agreement for sale of land, where in some of the clauses, which is actually clause 17 of your agreement, you have stated that this agreement adopts the sale agreement. And then there is a clause relating to completion, so that you say completion shall be 100 days from the date of execution of this agreement. You are together up to that point?
Yes.
Okay. Now, in the completion in the agreement, you have actually stated that one of the clauses that the completion shall be 100th day from the day of execution of that agreement. And then on clause 17, you have adopted the LSK conditions of sale. So it happens that it reaches day 95, completion has not really happened. And so the purchaser is really frustrated by the same. And so he wants to invoke the dispute clauses in that agreement. So you go before the court, and the court is faced with is grappled with an issue to determine on whether the LSK you realize that the court realizes that LSK condition is actually conflicting with the clause in the agreement. So at the same point, you're also a judge on the same matter. How will you proceed? How are you going to resolve the same?
Well, as a judge, I will state that since it is day 95 and the completion period has not ended, I will tell them you cannot file a suit in anticipation. And since they have already agreed that the LSK the completion period will be 100 days, and the LSK conditions of sale apply to your agreement to the extent that you are agreeable to, I will state that the completion period as agreed in the agreement is the one that stands, and we cannot file a suit in anticipation. So I will tell them to first wait for the 100 days to end. They cannot bring this a suit on the 95th day, because there is nothing that tells them within the remaining 5 days the completion will not be done. Yes, and the best thing. Yes, thank you.
All right. I think that is good. But then just one thing. So maybe something we should mention is that you realize there is a dispute between the provision of LSK conditions and then the provisions in the agreement. Which one will suffice in that case?
I will state that it is the provisions in the agreement pursuant to Regulation 279, section. I don't remember I think section 18 of the regulations, which state that the regulation of the LSK conditions of sale apply to the extent that the parties submit themselves to the LSK conditions of sale.
Okay, thank you. Another question, just still on the same unit, is that of course there are various types of transaction we'll do, and there is one that we call an off-plan purchase. Maybe to begin with, what is an off-plan purchase in your understanding?
An off-plan purchase is the purchase of a building plan by a purchaser in anticipation that the building shall be constructed. Yes, that would be my answer for what is an off-plan.
Okay, so quickly, the last question on that bit is so in the off-plan purchase, what are some of the documents you'll need to be the completion documents in where the off-plan purchase relates to sale of land in a regime of sectional titles, and also, yes, in the sale of land in auctional titles, and then so what are the completion documents you'll require in that case, and then when shall be the completion document, and how is it different from the normal sale of land?
I will state that in an off-plan purchase, and with reference to what you've said, that we will seeking reference to the sectional property, sectional title, I will state that the completion documents will be handing over of a registered building plan, handing over of the completion documents for the transfer of the building plan from the developer to the purchaser, and I will be guided by Section 9 of the Sectional Properties Act. Those documents that are usually handed over, and I will also state the sectional title transfer documents, and what else would I need? And what else? And
okay,
yeah,
that is okay.
Okay,
now the second question to you, Victor, is that maybe do you like music? Do you listen to music?
Yes, I do.
Which genre of music do you listen to?
I listen to Kenyan music. So what genre is that? I listen to Kenyan music mostly, and Nigerian Afro pop.
Who's your favorite artist?
Bien or Davido, any of them.
Okay. Now, Davido has actually become your friend, and he's realized that you're very, very brilliant advocate who can actually understand his interest and defend them. So we realized that there are some songs which he actually produced last week, and they're really hitting. But then you realize that Charity, a Kenyan lady, has actually seen very, very nice lyrics from Davido's newly released song. And she's actually trying to publish these lyrics, or rather owning the lyrics through a certain studio, which you have identified. So Davido has actually approached you or an immediate action. Which action are you going to take to defend the interest, and what kind of interest will you be defending?
I will be defending the video's intellectual property, and I will seek refuge in the Data Protection Act. I will I will not see any need for filing for sending a demand notice, taking into account that this is a matter where intellectual property is involved, and in the event that I send a demand notice, they may do away with the evidence. So I will file a complaint in the office of the Data Commissioner as for infringement of intellectual property. Yes, that's the action that I will take.
Okay. Okay, you have realized that his intellectual property is being impinged or rather infringed upon. How are you going to protect the infringement? How are you going to stop the infringement? Which action are you going to take?
I'll file restraining orders. I'll seek restraining orders from the office of the Data Commissioner, restraining this artist from releasing any lyrics that appertain the song that I believe to be Davido's.
What are you said you seek restraining orders from, and what are they?
Are they? I would say injunctive orders from the office of the Data Commissioner. I stand corrected if I'm wrong, but I will seek injunctive orders restraining this artist from releasing the lyrics of the lyrics that I firmly believe to be my clients.
Okay, so the last question to you is what can you name to me any any objections, any objections?
Yes, I can name. There's the objection that is filed by a person who believes to have an interest in land during the land adjudication process. There's an objection that is filed by a person who firmly believes he has an interest in a succession matter but has been left out. I will also say there is also an objection whereby I will say there is an objection whereby land is being compulsorily acquired and a person who firmly believes he has a valid interest as is not being taken into account, he can file an objection to the office to the National Land Commission. But with that, I stand corrected. Yes.
Okay, now Victor, that is so good. That is so good. But I am afraid there is one very, very important objection you haven't mentioned. But I want to mention a case to you so that maybe you tell me what it established and what you know about it. No, what exactly it established and what maybe it canvassed about. So there is a famous case, highly celebrated case called Mukisa Biscuit Manufacturing Company Limited versus Western Distributor. Have you ever heard of that case?
Yes, I've heard of it. Thank you very much for your guidance. There's a preliminary objection. Yes.
Okay. Now, on the preliminary objection, we understand that from the case I said, it's you have to base your PO purely on points of law. Can you name for me the pure points of law that you'll base your PO on, and that would be all.
I will state jurisdiction first, and I will also state res judicata second.
Any other?
Sub judice also, yes, sub judice.
Are you sure about it?
Yes, yes, I can raise a PO on grounds of that the matter is sub judice. Yes, I'm sure about it.
Okay. So thank you so much, Mwendo, and that is all from me. Back to you, Angelo.
All right. Thank you, Esbon. I have no question for Mwenda. Maybe I will take the next volunteer. We are left with 6 minutes, so we will try to get as many volunteers as possible. So we'll ask like few questions, and we give response as quickly as possible. So maybe Esbon, you can proceed and give your views on Mwenda. Thank you.
Thank you so much, Angela, and I apologize. I've taken really much, but it's because my candidate really is a conveyancer. Congratulations, Mwenda. Honestly, I'll have given you 18.5 out of 20 in this. So you've really answered almost all the questions I asked. And I noted in conveyancing, you are really smart. I was trying to avoid questions conveyancing. You even dragged some answers to conveyancing, but really did well. So on PO, on types of objection, you've really answered all the types of objections, but there is one you didn't mention. There is an objection that you raised. For example, we understand that during hearing, when for example, during examination in chief, you're not supposed to mention some questions. For example, you're not supposed to ask questions which suggest answers, otherwise called leading questions. So if you raise such kind of questions, an objection shall be raised. So that kind of objection is called an objection during during trial. So that is also another type of objection, but the rest were very clear. Then on off-plan purchase, you answered well. You just didn't mention about the completion. So for the option for off-plan purchase, remember the completion period, unlike in the normal sale where even the LSK condition provides that completion period is at 90 days from the day of execution. In off-plan purchase, completion period is actually determined by when the houses will be complete, and the completion of houses is also determined by the issuance of a practical certificate of completion. So the completion period will be determined after the houses are completed. So that can be 14 days or even 90 days. So it's usually discretional depending on the arrangement by the buyer and the seller. Then another question, I think the only question where I wouldn't have given you 1.5 was the question on the IP. You are right, you realized it was IP, intellectual property, but I expected you to mention what type of IP was it, and you realized that it was a copyright because this was a recording. Then the action you take, you kept on mentioning data protection or data commissioner, but I expected you to mention, of course, later on you mentioned about injunction or restraining orders, but the answer I expected was Anton Pila. So this, you can actually go read about Anton Pila and its brother, Mareva injunction. Yeah, that will, then also, I think you answered well LSK condition and conditions of sale and other agreements, so that if there is a conflict, LSK conditions is weaker. Sorry, the clauses in the sale agreement will always suffice where there is a conflict between it and the LSK condition. That one you answered so perfect. So thank you so much. That is a good a well done from Victor. Thank you. Back to you, Angelo.
Thank you very much.
All right. Thank you, Esbonoko. Victor, that was a great performance. So now I will take on the next volunteer. Please let's raise our hands quickly such that we can get as many volunteers as possible such that we can learn as we proceed with our meeting. So the next person, please, quickly. All right, Donna Atieno from UK.
Yes.
All right. UK mean United Kisumu. So, all right, let me check the next hand. You will come next. Were you here? All right. Very well. Thank you. So, I have a few questions for you, Donna. First,
Yes.
good morning.
Good morning to you, to Angelo.
All right. Thank you. I have like 4 or 5 questions for you, and mine are straightforward. Can you please tell me what is the role of criminal law, or let's say criminal justice system at large? Give me at least 3 roles of criminal law.
So the 3 roles of criminal justice, first will be to punish the offenders. And then there is to rehabilitate. So when offenders are taken to prison, the prison is mainly to rehabilitate them so that they can come back to the society. And thirdly, it is to deter the rest of the community from committing the offense, such that when someone is punished, it serves as a lesson to the rest of the community not to commit the same offenses.
Okay, thank you. My second question is, can you please tell me at least 3 defenses in tort that you know of?
3 defenses in tort.
Yes.
So there are several torts.
Yes. You can pick any, or let me say tort of negligence. I know there are a lot of tort like defamation. Okay. Or is it
Yes.
called, okay, let me just pick that one out, negligence.
Differences in negligence.
Yes. Tort of negligence, yes.
Well, I am really not sure. So I'll go and research more on that because at this point I am not sure.
Okay, thank you. Thank you very many. All right. My third question is, can you please tell me what you know about these 2 things? I'm now going to criminal law. Ultra voice convict and ultra voice acquit.
So
What is your understanding, or maybe you just distinguish or differentiate the 2?
okay, ultra voice convict and ultra voice acquit are pleas, types of pleas in criminal law. So ultra voice convict is when now someone is being charged. Ultra voice convict when someone has been brought to court, so they plead ultra voice convict to say that they had been charged on that same offense and convicted earlier on. Whereas in ultra voice acquit, it means that they had been charged of that offense previously, and they were acquitted of the same offense.
Okay, thank you so much. Then finally, or close to finally, you are an advocate, okay? Can you please tell me how you would proceed with the matter of a dead person and a minor in a civil trial?
So in a civil case, let me start with the minor. So a minor cannot sue or be sued directly in the name. So instead, when they are suing, they or being sued, they are sued in the name of the next in the name of the friend or next representative. Yeah. Whereas for a dead person, they can be substituted, so there can be probably an ad litem. I think it's an ad litem. Yes.
Okay, then now, finally, please tell me or give me 3 duties of a purchaser's advocate in a conveyancing or a conveyance transaction. Only 3.
In a conveyancing transactions, there are several parties. So a purchaser's advocate, a purchaser's advocate will be in charge of I'm confused, sincerely.
No problem.
I have a problem with conveyancing.
Okay.
Yeah.
So are you going to attempt, or you are done?
I am trying to think about it. So a purchaser's advocate will okay, I'll just go and read more. I'm not well conversant with conveyancing.
Okay, very well.
Yeah.
Gitari, I will proceed with giving my feedback, and you will take on the next volunteer. For me, I would say that you did really well, although there are a few questions whereby you are unable to give your answers. I know you know them. Maybe it is just that you have not prepared yourself for those questions. But I would give you a 16. I believe that is a good mark. You are clear and precise. When I say give me 3, you gave me 3. So that is also part of exam. So there's no need for you to go and give 6 if someone is asking for 3. So for duties of a purchaser's advocate, I'm not going to give it here. It's not that I don't have them, but these are some of the things that should be on your fingertips. So it is an exercise to all our members to go and research on duties. They did not come in our bar exams. So it means that in your bar exams, I believe there might be questions in that regard. So please go check that one out, because those are mandatory. However, I'm going to give my response with regards to how you proceed in these parties who are incapacitated, for example, diseased persons and also minors. For example, let me start with a dead person. So if the wrong is to the estate of the disease, so that is if in a civil matter, if the deceased was the defendant or the plaintiff, but the cause of action still survived and can be pursued, then the representative of the estate shall obtain a grant ad litem to sue or be sued on behalf of the estate of the deceased. Okay, so that is it. So for a person, I don't know if which particular order, maybe Esbon you will can, I don't know if it is order 18 or it is order 24. So the suit will abate, that is after 12 months. Okay. And let's say if someone died in the process when the case was ongoing, then you make an application for substitution. Say that now the legal representative of the estate of the deceased person will be that person who will take over and pursue that particular matter. But if it is a criminal case, for example, an accused person died, so then the consequence thereof will be the proceedings will terminate automatically. So that is it with respect to deceased person. But for minors, you have said well, they sue through what we know as a guardian or a next or next friend. Okay, so maybe in our next section we can give you to tell us how do you give the caption. Okay, so that is an oral question. And then finally, as a feedback on my part is on the aspect of defenses in tort. So I was giving you a general question such that you can give me as many as possible. Okay, and in tort, that first defense, which I believe you would have remembered, like volente non fit injuria. Okay, something called voluntary assumption of risk. So that is, or something called contributory negligence, or something in that vein. Sometime another defense is something called inevitable accident. Okay, another defense is act of God. we have defense of necessity, we have defense of mistake, then we have a defense of statutory authority. We also have a defense of limitation of actions. Then we have self-defense. So that is it on my part. I believe Daniel is also back. So that is all on my part, Donna.
Thank you. I think I'll need to read more in convincing and whatever you've pointed out. Thank you for your time.
Yes, please do. So Gitari, you will take the next person, or you can do it jointly with Odur if your questions will be also be brief or something like that, so that we can try to cover much ground. Thank you. Gitari, take it away.
Angelo,
Yes,
Gitari
yes.
tells me that she's away for a few minutes, but she'll be back soon. So let's give her time.
Okay,
Yeah, just
okay.
to maybe if you can bring me up to speed. It's now one person per person, or
Yes,
what?
we have tried one person per person for the last two volunteers, so that we can try to cover as much ground as possible. We are left with 40 minutes now.
All right. I think that's okay. That's okay. We can do that. So then I'll take the next person. I hope that's
Yes.
okay. For me, I think
Yes.
we will have, right?
Yes, we have the next person on call. That is her name is Weyusia. That is please unmute. Weyusia?
Yes.
All right.
No.
Daniel will take you through some questions. Thank you for volunteering.
Okay.
Okay. Just before we begin, I can't see your profile picture or your profile rather. Could you say hello?
Hello.
Okay, fine. So before I begin with you, I'd just like to say a few things from the session I had before and just the one that concluded. Guys, I'm not saying this because of the last session, but let's try. Let's try. Like these things that we can easily get, let's try. Like the roles of purchaser's advocate, roles of chargee's advocate, who is a chargee, who is a chargeo, who is a mortgagee, who is a mortgageo, who is a purchaser, who is a buyer, who is roles of the buyer, roles of the purchaser. Let's just try. Let me tell you guys, sometimes our lecturers make assumptions. I ask you, who is a buyer? Who is a purchaser? Who is a seller? Who is a vendor? And you can't give me an answer, or you can't tell me their roles. They already make an assumption that, okay, the person we're dealing with is not studying. So let's try those easy ones. I'm not saying they're very easy, but those ones, let's just try. The obvious ones, let's just try that we know them. Again, that's why we said it's important to come here to be asked those particular questions. So Donna, it is important. I'm sure the next time someone asks you those questions, you're going to have all the answers, even more than what they're going to ask you. So guys, let us not allow the lecturers to make an assumption that we do not actually know what's going on. So let's try at least those roles. Let's know those roles. Let's just try our best and know those roles. At least let it be that if I ask you the roles of the buyer or the purchaser or the roles of the vendor, you know those ones. Let's just try. Let's just try and know those ones so that you don't give them an opportunity to, to form an opinion even before you begin. Okay, so the obvious questions, let's try. Let's just get clarity. Let's ensure that we know what those questions are about to give you that, that next step, to help them know that actually you know much. So try your best to know the obvious ones. Don't take anything lightly. Just try your best and you'll be fine. You'll be okay. So Donna, try. Just try when you get time. I know they look so easy. They're even negligible. Sometimes you even tell yourself, why should I read all these roles? For what reason? I'll be able to think very quickly. But sometimes during orals, when things, in the heat of all these things, sometimes you can forget if you didn't read. So let's try, guys. Let's try. Then another thing that I'd like to say, I've realized most of us are saying, I stand guided. I stand guided. Now, our lecturer told us you can only stand guided after you have been guided. Okay, so if you're giving me an answer and you're already telling me you stand guided by your answer, or what do you mean? I know sometimes we say it to mean that it's my opinion, but you can guide me. I remember it was Miss Mongari. You can only stand guided after you have been guided. Okay, so it's after I've given you the right direction that you say, okay, that's nice, my Lord, I stand guided. You've guided me. So you can't stand guided before you are guided. So let's also try and not say that all the time. It could be a problem. I know it's easy to say. I know lawyers say it a lot, and sometimes you just feel like you want to say it. Please, let's just be careful with that. Then another thing is just start. You take so much to say that, again, that could be a problem. So I know sometimes we might end up saying it, but try as much as possible not to have so much of that in your answers. Just try your best. Then I think the person I was talking to last time said, can I please pass the question? Guys, I would like to give you guys a slick answer. Now, I'm not saying that everyone should use it, but please just tell the lecturers, I do not know the answer, but after this session, I'm going to do my research and ensure that I know the answer. Thank you for the question. Let's not say, pass, I don't know the answer, I can't answer, or whatever. And if it's a question about something that you guys have maybe it's a topic that you guys have not covered yet, be honest. We have not covered that topic yet, but after this session, I'm going to go through it and ensure that I know the answer to those particular questions. Okay? At least you're telling him that, you know what? I'm not just lazy. I'm going to do my best and actually know the answer. Then saying pass. Life is not like that. We have to try. And if you have an opinion, or at least you know something about it, just try. Say whatever you think and say after that, I'm not very sure, or I haven't read about it extensively, but immediately after this session, I'm going to read about it and ensure that I know the right answer. Again, don't try using that in all the questions. Like from the first question you asked, the last question you asked, that's the only thing you're saying. It means that you've not answered any question. But it is an answer that you can use when things are really tough, when you are thinking about saying pass. So let's not say pass. Let's just try our best not to say pass. I can't answer the question, or that is too hard, or I haven't read that, or I don't know the answer. Okay? Let's just say, I don't know the answer right now, but after this session, I'm going to do my research and ensure that I know the answer to that particular question. Okay, guys, I hope that helps. How are you, sir? I see your hand. There's someone else. You have a question?
Yes.
Not really
Yes.
volunteer, so I was waiting for you to give that brief you are giving.
Okay, fine. I'm seeing this Sharon. I think Sharon has a question. After Sharon, then I think we can have a session with you. Yes, Sharon.
Okay, I just wanted to ask, what if, okay, fine, they ask you a question and then you're not like you're not well versed in that, say maybe it's conveyancing. So could you like kindly politely ask them to maybe ask other question, maybe in commercial transactions or maybe probate or succession, or that could be, I don't know, how can they check that?
Okay, so sometimes actually they give you that option. They ask you, okay, we've realized that you don't know much about probate. Should we ask you about conveyancing? And you end up saying yes. I think it's better if they propose it to you than if you propose it to them. Because what if you propose it to me and I ensure that I ask you very technical and very hard questions in that thing that you think you know? So then what? So you know nothing at all, even the thing that you think you know. So it could be risky. It could be risky proposing to them to ask you questions for that particular unit. It could be risky. We're expected to take all these subjects seriously and know the answers. So you try your best. But if they ask you that, would you be okay if they ask you questions from another unit? I mean, you can take it. Why not? If things are really hard, just take it. But you proposing it to them, I think it could be a bit harsh. If not harsh, they could end up asking you very technical questions about something that you do not know, and you end up not knowing them. Then you end up looking like a fool. That could be my answer. So I think it's a bit risky if you direct them towards that, especially if they have attitude, or if they decide to ask you very hard questions, yet you said you can answer those questions. Okay, but if they give you the option, yeah, I think you can take it, especially if things are really hard. You can take it. Sharon?
Okay, thank you. That helps.
Yeah, because I mean, you could be tying yourself. You think you're coming out, but things are only getting worse for you. So yeah, if they give you the option, take it. Of course, with a pinch of salt. Again, don't be like, yes, 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 yes. Just say yes. We could do conveyancing. Like, just behave like, you're not so excited. You know that you're now going to, like, just have your poker face on and just try and do your best anyway. I hope that's okay, Sharon.
Thank you. Yeah, thank you.
Welcome. Again, don't propose. Let them propose. Were you here? I think now we can do something. You ready?
Yes.
Okay, well, you sir, kindly introduce yourself.
My name is Weyusia Shivuyenje Audrey. Registration number 2023-1160 from Class G. A member of FAM 9.
Okay. That's good. Well, do you know anything about Giela versus Kathman Brown? Giela versus Kathman Brown.
The case of Giela versus Kathman Brown deals with the question of injunctions and the requirements that have to be present for a court to grant an injunction. Number one, is I don't know if it's the applicant or the claimant, has to show that he or she has a prima facie case. Number two, he is likely to suffer irreparable harm or damage. Then the remedies that they are seeking will not be granted by any other court.
Okay.
That is.
That's all.
Yes.
Okay. That's fine. Just another question. What are the essential elements of a contract? If someone brought a contract to you today and you are to sign it, or you have a client who is just about to sign a contract, what would you be looking for?
Okay, I will look at first the consideration, offer, and whether there is acceptance of the same. Then I will also look at whether there is the parties to the question have capacity to contract, and whether the subject matter in question is legal of the contract.
Okay, that's fine. What's a bail and what's a bond? Can they just differentiate the two, or if they mean the same thing?
Pardon?
What's a bail, or what's bail and what's bond?
Okay, so for bail and bond, they are both securities that are undertaken by an accused person that they will attend court or they will continue listening to attending court to their case outside court. So the difference is, while bond mainly deals with that aspect of security, for example, title deeds, pay slips, logbooks, and such documents of title and security. Bail, on the other hand, can be monies which are deposited in the court.
All right. Who is an advocate?
An advocate is a person who has undertaken the requisite training, starting with the Bachelor's of Laws, and has undertaken the advocates training program, has been admitted to the bar, and has signed the role of advocates as an advocate.
Okay, what's a leading question?
Okay, a leading question is usually asked in cross-examination, and these are questions whose answers are usually you expect a yes or no answer from the person you're cross-examining.
Okay. My last question. Could you maybe differentiate to me the difference between insolvency and bankruptcy, if there's any?
Insolvency deals with artificial persons such as companies, whereas bankruptcy relates to natural persons. The meaning of the terms is that a person is it's a state or a condition which is determined by the court that a person or a body, corporate, is unable to meet its obligations or liabilities as and when they become due.
Okay. Do you know anything about the case of DEMA Management versus the county government of Mombasa and others?
Yes, was it about title or bona fide purchaser of value? I think that's all I can remember. I have not really read it. I think it's a recent case. I have not really read it.
Okay. That's okay. That's okay. Thank you so much.
Welcome.
Okay. So I think you've done well. I think you've tried as much as possible, as much as you can. I'd give you good marks, but I think also there's room to do better. I mean, for the questions that I asked you, but I like the fact that, however hard, however easy it was, you're able to say something. You didn't just keep quiet and say, you know what, I don't know. I have no idea. So you can only do better. And I know and I believe you can do better because, I mean, you know much. So you're able to know whatever is remaining. So please, again, I shared this case in the group because I think it's quite controversial right now, for lack of a better word, controversial. Maybe it's not. And I think it has formed part of so many discussions when it comes to conveyancing. DEMA Management versus County Government of Mombasa and others. Please, I shared this in the group. Please just try. Please try and read that case. Please just try and at least have an idea about it. Please try and read the case of DEMA Management versus County Government of Mombasa and others. Just try. But I think you had an idea when you talked about bona fide, the principle of bona fide purchaser for value without notice. But just read what the judge said or what the Supreme Court said in that particular case. Types of bail, I think you got that right. Giela versus Casman Brown, okay. It's about temporary injunctions. Okay, again, this one's also, let's just try and have them on the tip of our fingers. We have prima facie case, irreparable damage, balance of convenience. Lately, the Supreme Court added public policy. You can add it as the fourth one. But there's prima facie case, irreparable damages or damage, then balance of convenience. Then again, try as much as possible to understand when you talk about balance of convenience, what do you mean by balance of convenience? What does that mean? Irreparable damages, what does that mean? When I say that we have irreparable damages, what does that mean? Prima facie case, what is a prima facie case? What does it mean in particular? Bail and bond, I think you got it right. Bail, money paid in cash. Bond, an undertaking or promise to give something. Could be, how do we call it? Could be property under MPSR and all that stuff, or could even be the way you said, a title deed. Which is the question that I asked you that is important? What is a leading question? A question that suggests the answer. What is a leading question? A question that suggests the answer. Who is an advocate? Mr. Maloa told us that it is very simple. Don't even think about so many things. An advocate is a person whose name is in the role of advocates. Your name cannot be in the role of advocates if you're not an advocate. So an advocate is a person whose name is in the role of advocates, full stop. You don't even need to say much about it, and all that stuff. I know sometimes you want to explain, but please just make it that plain and simple. An advocate is a person whose name is in the role of advocates, full stop. No one will ask you more. Your name cannot be in the role of advocates if you are not an advocate. It's that simple. The essential elements of a contract, again, let's just try. Just try. These ones, just try. Capacity, which I think you explained very, very well. Congrats for that. We also have intention. We have offer. We have acceptance. We have consideration. Again, you explained that very, very well. Then we have legality. So legality, consideration, acceptance, offer. Oh, you can just start with offer, acceptance, consideration, intention, capacity, legality. What else did I ask you that you'd like me to clarify, Beyusia? Please.
Oh, I think the other question was on the difference between insolvency and bankruptcy.
Yeah, insolvency and bankruptcy. I think this is a discussion that we had last time, and we're having it today. So bankruptcy happens where a court has given an order, or a court has declared an individual or a company to be bankrupt. What is the meaning of being bankrupt? Being unable to pay your debts. Being insolvent, being unable to pay your debt. That's why I think you said insolvency and being insolvent is, you're not able to. You are in a situation where you're not able to. But bankruptcy is when the court, you cannot just say that someone is bankrupt and there's no court order. I know sometimes we say this about, I have no money, I'm bankrupt. You're not bankrupt. You're only insolvent. You don't have money. You cannot pay. It's a state. You're only in a state. For us to say that you are bankrupt, it must be that a court has given an order declaring you bankrupt, you as an individual. Again, we have to underline individual. So you cannot be bankrupt unless a court has declared you bankrupt. So that is bankruptcy. Then we also have bankruptcy proceedings. What happens after a court has declared you bankrupt? Now, we have insolvency proceedings. This is when a company is unable to pay its debts as and when they fall due. Where I think you talked about something, a state, and we're trying to make a difference. So the state is being insolvent, but insolvency proceedings or insolvency now denotes where a company is not able to pay its debt. I know sometimes there's a bit of a difference there. There's a bit of a confusion there. So insolvency proceedings take place when a company is not able to pay its debts. Bankruptcy proceedings take place when a court has declared an individual to be bankrupt. So don't go again before the lecturer and say bankruptcy is when an individual doesn't have money and they cannot pay them. No, it's when a court has declared. You cannot be bankrupt unless a court has declared. I hope that makes sense. Insolvency proceedings is when now we're talking about a company. Okay, and that there are two types of insolvency. When we say that you are insolvent, there are two explanations. I hope we know those two. It's either you don't have money or you have money, but it's in immovable form. You're not able to pay whatever you're supposed to pay because you've not moved them into movable form. You are not liquid, for lack of a better word. Is that okay, Weyusia? Or do you have another question?
I don't have another question.
Okay, anything you disagree with, fine. I think we can also have a discussion. Are you okay?
Yes, I'm okay. I don't think there's anything that there's a question that you asked and maybe you haven't addressed.
Okay, that's nice. I like your resilience. I like that you tried your best to answer each and every question, and you said something. That's who lawyers are, man. Sometimes things are very hard, but you have to say something. You can't just sit back and say that, I don't know. I have no idea. So that's one thing that I picked up from you, and I like it. And I think maybe the rest of us can also learn from it. Sometimes even if you know, or even if you know, sometimes even if you know you don't know, or even if you know the answer, just try. And I think when I asked about something that you know very well, you tried as much as possible to do as much as possible and talk about it. Again, that is good. sometimes I feel like the intention behind convincing, behind orals, is just to see if you've been learning. I mean, if you have any content in your mind, if you're able to stand by it, and if one day you go to court and you get a hard question, would you still be able to speak, to say something? And I think that's a test that you passed, and you passed with the flying colors. Yustia, I wish you all the best, and I hope to hear from you again next time.
Thank you.
Okay, just keep going, keep digging, keep going, keep digging. You're okay, you're on the right track. Okay, I think we can have Hesbon. Hesbon, go ahead.
All right, thank you. Thank you, Bwana Oduor. Do you have a volunteer? I'll be very brief on this because of time, really.
I think we have someone, Hesbon.
Yes, keep Kemoi, please unmute.
Oh, sorry, Kip Kemoi. All right, I hope so, Kip Kemoi, you can actually hear me. Kindly confirm.
Keep Kemoi, we cannot hear you. Maybe you can unmute, please. Felix?
I don't know if Felix is having a challenge with his device. I can't hear from him.
Yeah, maybe.
Okay, can you have another volunteer maybe to any other volunteer before you roll our marble?
He's not on our side. Someone? Very well. We have 3 people, Esbon. So I believe we will go with oh, she has disappeared. Yeah, we can go with Kelvin Mwangi, Wanjiru. Then we will close with Kamuri Marian. So Kelvin Mwangi, please unmute.
Yeah, I have. Can you hear me?
Okay, Kelvin Mwangi, how are you?
I'm very fine, Mr. Hesbon.
Okay. All right. We are going to have a brief session with you. Very, very brief, really. So, my first question to you will be: you understand what divorce is?
Yeah, I do.
So, in Kenya, Kenya is actually regarded as a default-based state when matters divorce. What is the meaning of that phrase? No, not default, fault-based state in respect to divorce. What is the meaning of that?
Okay, I believe under the Marriage Act, which we all know it is based on ecclesiastical foundations, you have to prove the various grounds of divorce before a court of law, before the court grants that divorce decree.
Okay. So now you said divorce. So now I understand, and we all know that divorce is actually based on different grounds, for example, adultery, cruelty, desertion, and whatnot. But then my question is really not on grounds. So assuming that there is a person A and there is person B. So person A is actually moving the court by way of petition so that he can get divorce orders. But person B really doesn't want, so he wants to defend himself. So what are some of the defenses that person B can raise for him to salvage the marriage?
Oh, really, can you come again, please? I didn't quite get the last part of the question, kindly.
Well, so I was saying like we have two persons. It's actually a couple. Person A, a husband, and person B, a wife. So a wife, person A, has moved the court through petition. You understand that in divorce we move the court through petition. So divorce petition has moved through the court so that she can get divorce orders. But then person B, the wife, is not convinced that he's actually objecting to divorce cause. So he want to object the motion by rather the petition by the husband. So what are some of the grounds or rather the defenses he will be citing in his response?
Hey, well, that's that's quite a complicated question, but I'm going to try it anyway. Some of the defenses that the wife can have against the petition raised by the husband, if I can understand that question, well, which defense? I really don't know. I really don't know. Maybe I will have an opportunity of relooking into that question, and maybe next time I will have an answer. But for now, I do not know.
No problem, Kelvin Mwangi. So now, Kelvin, after your KSL, you realize that you really want to become a scholar and just like obtain a title. So like you have an admirer who is called Professor someone. So like you want to also get to the rank of being a professor. So you study very hard, you finish your doctorate and everything. And of course, you become a professor. So, but you realize on your ID is written Kelvin Mwangi, and I don't know the third name. So you want everyone to actually be referring to you as Kelvin, a Professor Kelvin Mwangi, and it be known all over, all your documents, every person refer to you as Professor Kelvin Mwangi. Uh, how would you, like, what action are you going to take so that is realized?
I think under the law, there is something that is known as the deed poll. The deed poll, the benefit or rather the essence of having a deed poll is where it gives you an opportunity of changing your name and aligning your names according to the titles that you want and the members of the public to be referring you as per those titles. If personally I want to be referred to as Professor Kelvin Mwangi, and that to feature in my various identification documents, what I can have is to go fill in the forms, the deed poll forms, and maybe my identification document will feature the name Professor Kelvin Mwangi.
Okay, thank you, Kelvin. The last question to you, a brief one, is so what do you think are some of the characteristics of a good story?
One of the characteristics of a good story is that it must be captivating in the sense that you have to incorporate the various artistic styles, such as having a proverb in your story that can capture your audience. The next one, it must flow, like you have to have a flow in your story, an ability to move your audience. Can you hear
Sorry,
me?
Kelvin, maybe I should have been direct and said, let me limit you to, you are an advocate, a trial advocate. So you supposed to maybe tell a story, or your client, one of your witnesses is supposed to tell a story to the court. So what are some of the characteristics of a story that you're going to ensure that story being told by your client is actually a story that really will help his or her case? So what characteristics will that story have? Which characteristics are you going to infuse in that story, or are you going to ensure that that story has?
Wow, okay. Right. Okay. The various ways to make sure that my client's story, or rather the story that shall be given by my client is well. Okay. I don't know what, because sometimes I do think you as an advocate from this side, you will only be asking the question, and the way you ask those questions is to ensure that examination in chief, of course, you are examining your client in chief. You have to make sure that you align your story, or rather your questions, on the basis of the 5 Ws and 1 H, so that when you are aligning your questions on that basis, they will guarantee that your client is going to give a story to the court. But ensuring that your client gives a good story, I think it is something that is not within your control. What you have in your control is to ensure that you ask questions aligned to the various aspects of examining in chief. But yeah, if I can understand your question to mean that way, kindly.
Okay. Now, the last question, which I'll really request that you answer in 45 seconds, not more than 45 seconds, is what is the difference between liquidated and unliquidated claims?
In liquidated, in a claim that is liquidated, you have to, if it is, there is a mathematical formula for liquidated claims, an arithmetic mathematical formula. But for unliquidated claims, you are leaving it to the court to make that determination on the amount that it is going to award in terms of damages.
Okay, thank you so much. So Daniel, with your permission, allow me to use at most 45 seconds to just respond to have a comment on Kelvin's presentation. I think he's done really quite well. You've done so well, Kelvin. Kelvin. I will give you more than 16 marks in these. I said more than 16 marks. So where I noted you had a challenge was the question on divorce. I understand that most of us would maybe just expect to be asked what divorce is and what grounds of divorce is, and then you stop at that point. So a challenge will come when you're asked about defenses in divorce. So defenses in divorce petitions relates to, for example, the collusion, defenses of connivance, defenses of recrimination. For example, you are basing your divorce cause on adultery, yet you two are more adulterous than even the person who is actually the respondent in the matter. So we have various types of defenses, which I'll implore you guys to go have a look at. For example, like in the first statement was Kenya is a fault-based state when it comes to divorce, so that a person must have established that there is a fault between or existing between a marriage, so that you use that fault to ground your petition, your divorce petition. So there must be a fault in the first place, and that fault must not have been colluded. The parties should not collude. Actually, that is why there is an aspect of collusion as a defense, so that if you collude and say, mimi na a person A and person B agree so that they got divorced, like in the US, in Kenya cannot be allowed. So those are defenses. And then another question which I noted you had a challenge was the question on the storytelling. Remember, when you asked about storytelling, quickly think about the trial. And in trial, I think Angelo presented well the opening statement. So that in opening statement, you're being tested about the storytelling. How are you able to tell your story? How is the client able to tell his or her story? And that is why when you say you're going to prepare your client for hearing, that is actually you actually shaping their story so that it be a story that can really be a helping story before the court in his or her case. A story, such kind of a story, is expected to have a theme and a theory. Understand? So that is what I expected. Just those two, a theme and a theory. Then I think for liquidated and unliquidated, you are very clear. Liquidated actually just means that we already know what is the exact sum of money you are seeking in this suit. And liquidated, you don't know. So that is why the court will undertake what we call formal proof, so that it ascertains exactly the amount that the defendant or the plaintiff rather is claiming. Thank you. That will be all. Back to you, Angelo or Daniel.
Okay. Thank you, Esbon. Thank you, Kelvin. I believe we cannot chase away Marianne from the seat of justice, as they call it out here. So, Daniel, maybe we can take the next 5 minutes such that Marianne can answer a few questions, if that is okay.
Yeah, no problem.
Okay, Marianne, maybe you can unmute. Kelvin will come back to you. I can see you have raised your hand. Marianne?
I'm really sorry. That's
Yeah.
an old.
Okay. Yes. Marianne, I'm not going to ask you how are you, but I'm going to go straight to questions. Can you please tell me what are the types of jurisdiction you know? Give me at least 4. Are you there?
Yes, I will talk of geographical jurisdiction.
Yes.
Not, and this is one describes where the course of action happened. And then we have the pecuniary jurisdiction, which is based on the amounts, the amount limit set by courts. And then I'll talk of subject jurisdiction. For example, whether it is land, employment, and yeah, I think I only know of those 3.
Okay. Thank you. Please state any 4 different types of immunity you are aware of. Just state any 4 types of immunity you are aware of.
I know of diplomatic immunity,
Mm-hmm.
and then there is the spousal, I think, and advocate client, and one of them, state officials.
Okay. Marianne, let me say you are a magistrate sitting at Karachuonyo Law Court. Mark Mackenzie has been charged with murder, and the prosecutor brought him to your court. What will you do? You can unmute, Marianne.
I would refer the matter to the High Court, because normally murder cases are heard in the High Court, despite the ruling in, I can't recall the name of that case, Charles Nyaoke case, where they held that murder cases should be held even in the magistrate courts, but it is yet to be implemented for grounds that it is like a sort of discrimination to people charged with murder because their chances of appeal are reduced. But yeah, they are still being conducted in the High Courts.
Okay. Finally, let's say you are a pupil working at Olayo and Company Advocates. So now you have been instructed by a company known as Marine Cargo Limited to clear a certain cargo that is coming from China. Okay. Then those are your instructions. So, but later when this particular cargo came, someone by the name Esbon Oko came to you with a judgment, let's say in HCC number 21 of 2023, asking you to release that particular container to him. Now, the client has come to you in the office. Of course, you are with your supervisor or pupil master. He is afraid that indeed there is an imminent threat that he is either going to be sued by these Marine Cargo Haulers Limited and by Esbon Oko. Can you please tell me how you would advise him to proceed in this regard?
Who has you said Hezbollah has the judgment?
Yeah, you see, your client has instructed you, or let's say another person. Okay, your client has instructed you to clear a certain container from China. Okay. Okay, I'm using you as a pupil. It is because I have no other person to use. But let's say there are 3 persons and you are an advocate. Okay, kuna watu watatu, sawa sawa?
Yes.
Okay. Then this person is, let's give his name as Gitari. Okay, has been instructed by Marine Cargo to clear a container from China. Okay, the container has arrived. Okay, but now instead of him coming to collect his container, some other person has come to you to serve you with the judgment, telling you that you should release that particular container. Okay, remember that judgment has no authority or has not been instructed by this Marine Cargo for you to clear the container and give it to this particular person who has come with the judgment. So how can you now advise Gitari on these 2 parties who are claiming over this particular container? You can unmute. You can't hear you.
Oh, sorry. I will advise my client to file for interpleader application, where the court will have to determine who is the real owner of the cargo. That is order 34. And in that case, my client will be willing to depart with the cargo on the decision of the court.
Very well. So what would you be demanding in this instant if you are willing to let the container go? What would you be demanding?
I'll be demanding that the court determines who is the owner of the cargo between the 2 parties. Yes, and I will have to not have colluded with any of the parties before moving to court. Yes, that's it.
Okay. So anyway, since we are 8 minutes past our time, I will proceed to give my comment, and I will start with this last question. So when I repeated, like, what will you be demanding? I was looking for a specific thing. That is, you would also want the court to determine who among these 2 parties shall be liable to indemnify you the cost and the charges of the importation and demurrage charges of that particular container. Now, you have used money even for storage purposes, so you cannot just release the container like that, even if the court order. So, of course, the charges, you would want to be indemnified. The cost, okay, I was looking for for that in that particular question. All right. Then on these other ones, I believe you did really well. And I just want to clear up on something, because there were some questions that were straightforward, like that one of a murder charge. Of course, you have the general idea, but you have failed to mention jurisdiction. Okay, you have discussed it, but it is good sometime, in exam people look for a certain keyword. Okay, so it is the jurisdiction that you lack, and that is why you say that you will refer this matter to the High Court. But I know there's always a particular question that comes. What if there is no High Court around? Okay, what then happen? Maybe the High Court is 200 kilometers away. Okay, what then happen? And this person won bail or something like that. I believe maybe we might ask that particular question some other time. But I was looking for even that particular word, jurisdiction, for you to mention it, and you did not mention. And yes, and when I was talking about the different types of immunity that so we have diplomatic immunity, we have immunity from prosecution. Okay, so we have something known as judicial immunity, we have sovereign immunity, we have state immunity, which you mentioned. Okay, we have presidential immunity. All right, which is which I believe you answered well. Then finally, on the aspect of jurisdiction, and this is sometimes we do assume when we are talking about even in criminal, when we are doing criminal litigation, civil litigation. Okay, the aspect of jurisdiction. Okay, so we have geographical jurisdiction, we have pecuniary jurisdiction, which you mentioned, original jurisdiction, inherent. Sometime in one of these sessions, we are going to ask people what is the understanding of inherent jurisdiction. We have appellate jurisdiction, we have limited jurisdiction, we have jurisdiction in the first instance. Okay, so we have second instance jurisdiction. Okay, for example, that one refers to whereby you hear cases for the second time, whereby first instance jurisdiction is where cases for the first time. But like you see, these jurisdictions that are mentioning, they fall under a certain category of jurisdiction. When we talk about original jurisdiction, High Court has original jurisdiction. What do we mean? So that is it. You are clear in your answers. I would also advise that you read more. And this was a great attempt. I can give you a 16. So you did really well. We are sorry for extending time, but I hope maybe next time we will begin at 8 p.m. such that we can have discussions with more people. So, and then Daniel, before you come, one second, I can maybe say one thing. You see, when you are answering questions, and this is now to everyone in the group, sometimes you have to be engaging in the sense that, for example, you can say thank you for that question. Okay, that is an interesting question. You see, that question is problematic. There is a way that you can always begin by answering the question. You can go straight. Oh, that is, you see, there's a way that you can say it such that you can reduce monotony. So that is something you need to work on. That is to everyone. So not to say thank you for your question every time that you are asked a question, but you can say thank you for your question. That is an interesting question. Then you go again like that one. So that is what I can say for now. Thank you all, and then we will meet again on Saturday. God bless you.
Okay, Angelo, thank you so much. Thank you so much for taking us through that last session, and thank you so much for your insights, and for Hesbon and for Victoria, all of us who are able to join today, and for those who are able to volunteer themselves today for this session. Guys, One thing that we have to do is let's keep learning. Let's keep learning. Someone makes a mistake today, don't make it tomorrow. Try and learn from their mistakes. Try and learn from their successes. Let's just all try and improve. Let it be that, you know, the mistakes that you made in the first session are not made in the second session, not made in the third session. I know we are learning one day after another, but let's just make sure that we are learning. Let's learn from mistakes made by other people, and also from our mistakes, and we will be good. We'll be fine. Let's keep reading. Just keep digging, guys. It's just now after KSL, you'll be able to do every other thing. So let's just do this for now. Just keep studying. One thing I can tell you guys are studying. The answers that I hear from you guys are very, very good answers. The volunteers that we have here, everyone is able to answer. Everyone is able to volunteer themselves. People are ready to, to offer themselves. People are ready to answer questions. That is a very, very good sign. In my opinion, you guys are doing really, really well. Your answers are sensible. You guys are fine. So just keep studying, keep digging. May you receive that grace. May you continue to be confident, and may you just have that power to keep learning more and more and more. Keep digging, guys. Keep studying. Just keep studying. Just keep doing your best. I'm not saying you study 24/7, but when you get that chance, just read 1, 2, or 3 things, and you will be fine. You will be fine. I can promise you, you'll be okay. Just put in the work. You will be fine. So I'd like to finish this session with a word of prayer. Yes, next time we will start early. Our Father, art in heaven, Lord, we thank you so much for this evening. We thank you so much for your grace. We thank you so much for covering us, for guiding us and leading us until now, Lord. As we leave now, for those who are going to sleep, may you be with them. May they sleep well and peacefully. May they rest well for the next week. King of Kings, as this class continues to study, Lord, may you guide them, may you lead them, may you walk with them, may you go before them, King Jesus. Lord, we worship you, we adore you. We thank you for everything, and it is in your mighty name that we pray and believe. Amen. Thank you, guys. It was really nice having you guys. We'll meet again next Saturday. Again, we say that if you want to meet within the week, let me know. Let me know. We'll make plans and we'll see what we can do. I know we've had those who are suggesting that we do some convincing questions from the project marks. I'll continue to discuss that with my group members, with my colleagues. If we're able to reach a consensus, maybe at one point we'll be able to look at those project marks and see how we can help you guys. Thank you, guys. Thank you, guys. Thank you so much. Have a good night. Bye.
Be blessed, team, for taking us through.
Thank you.
Thank you.
Be blessed.